Not surprisingly, I practiced this speech last night after the Cubs-Phillies game, which, by the way, the Cubs won. And I relearned a really hard lesson, and that is it's really difficult to talk for 45 minutes. So I'm going to try my best today. So I wanted to, well, by the way, does this seminar really go from Monday through Thursday? Do I have that right?
Most of the classes are Tuesdays. Monday's golf.
Monday's golf, okay, that's good. I have to tell you that before I was asked to speak here today, full disclosure, by the way, lawyers like to say full disclosure. I never knew there was such a thing as the Iowa Funeral Directors Association. I had no idea. But apparently there is. And I had visions, okay, that everyone would show up wearing, black or gray. Not that that's bad, but it's good to see some different colors in here. And I have never worked with a funeral director, let alone ever met one. I grew up in Indiana. My parents both passed away in the last 10 years. My brother still lived in Indianapolis. He took care of everything. So all I had to do is show up. What do you call it? The homily, the speech?
Eulogy.
The eulogy. You can tell I'm really experienced. So that was my job. So bear with me. I mediate cases where either someone's been seriously hurt, they've been fired from a good job, they've suffered the loss of someone, a death caused by someone's negligence, or they feel they've been cheated in a business deal, or a partnership agreement, or a family trust or family farm dissolution. So that's my world, and it's probably a lot different than yours. So I was asked to give some techniques on how to resolve conflict, and I have to approach it from the legal point of view, my experience, because that's what I do every day. And it's probably different than yours. I mentioned this to my wife, Kathy, last night. I said, I can talk about some things here, but probably everyone in this room has tried these techniques, or most of them, and I'm not sure I'm going to say anything new. And she's pretty wise, so she said, well, maybe that's true, maybe not. But maybe if there's one or two takeaways that people can get in resolving conflict, maybe that's good enough. So I thought I'd start with sort of a different question, and that is, what is the most dangerous thing that you have ever done? Think about that for about 10 seconds. I'm hoping I can get one volunteer to give a 1 or 2 sentence description on the most dangerous thing they've done. Any takes?
In life or in business?
Anytime.
I forgot my wife's birthday.
That's dangerous.
Oh, that was stupid, I'm sorry.
Well, here's my quick story. So when I was in college, I got a job, summer job, as a roofer in my hometown, Porter County Roofing. Well, I knew about as much about roofing as I do about making funeral arrangements, okay? Nothing. So first day on the job, I was assigned to do the commercial job, which is hot tar roofing. Then I was assigned to run the kettle, which is just a big cooker. So you get these big rolls of tar. They probably weigh 75 or 80 pounds. You balance it on the lip of the cooker, which has a lid. There's a stick that holds up the lid. At least this was 1977, okay, really technology savvy. You balance it on there, and you take away the stick, and then you push it in. And as soon as you push it in, the lid falls, and so you don't get any splashback from the hot tar, which, by the way, is heated to 400 degrees. Okay, I knew nothing about this. So I'm on the job site for maybe 20 minutes. They show me how to run the kettle. It's a 3-story building. and I'm getting everything set up. And somebody calls down from below, hey, we need the tarp, let's get going. Well, what they forgot to tell me was they had a hoist up above and a pulley system. So I would put the bucket on the rope, pull it up, put it back down. This bucket holds 6 gallons of tarp, okay, so it's pretty heavy. Well, these guys, they're all older guys. I don't think they appreciated having a college kid working on their crew, so tell me anything. So there's a 3-story light that goes up to the top of the roof. They want the tar like right now. So what did I do? I started to climb this 3-story ladder with 70 pounds of 400-degree tar in the bucket. I made it to the top by the grace of God. I don't know how I did it. These guys looked at me dumbfounded like, are you serious? Did you go to college? It was grace of God that I didn't splash it on myself, drop it, fall off the ladder. So later on that day, we were checking out, punching out. Mr. Lohmeyer grabbed me and says, hey, come here, I want to talk to you. So he says, Paul, do you realize what you did? Keep in mind, if you had stuck your hand in that tar, you could have yanked your arm up and you would no longer have a hand. Okay, so don't do that again. So that was the most dangerous thing I've ever done. Why do I tell this story? Because the second most dangerous thing I've ever done, I think, today, is give you a speech on a subject I'm not familiar with. So like I said, I'm just going to approach it from my experience as a mediator, which I've been very blessed. I mediate cases every day. I used to be a trial lawyer. I did that for 33 years. In 2014, I switched over. I knew a lot of lawyers. I thought maybe they would hire me to mediate their cases. It turned out pretty well. So I was thinking about what to do. And to me, there are 3 stages of dealing with emotional clients, okay? I think the one thing we probably have in common is from time to time we deal with a lot of emotionally charged meetings, right? So I think there's 3 stages to those kind of meetings. And I think the first stage is super important because it kind of, it sets the tone for the rest of the meeting. And keep in mind, a legal mediation probably differs a lot from yours because we have the 2 sides, the injured party, the insurance company, or the employer, in different rooms. They never get together. We used to try to do joint meetings, just a meet and greet, but lawyers being lawyers, they couldn't help themselves. They'd want to talk about, well, hope you guys realize this and this and this, and you don't have a good case. It went nowhere, right? So now we meet separately. Confidentiality is a big part of legal mediation, probably not the same as what you guys deal with, because I'm working separate rooms, okay? So there's a lot of difference there, but I think there are some things that apply to both situations. I think it's important. I think tone of voice is really important when you're dealing with people. Because if you talk like this to start with, and you start talking about these are going to be the ground rules, how does that come across? It's like you're attacking someone. So I like to, I'm soft-spoken anyway, so I like to approach it with a softer tone. I think that is important, but at the same time, there's a little bit of a balancing act because you also want to be firm. In the mediations I do, I want to make sure that folks understand there's one person, and I don't say it this way, but I want them to know there's one person who's going to lead our discussion today. And that's me. I want everyone to feel free to speak their mind and without interruption. I think that's a ground rule that's really important. But I'm going to be the one leading the meeting. And by the way, I know there's probably there may be some disagreement on how to do things today or plan a funeral service. That's not unusual. There's going to maybe be some compromise involved. Don't be surprised if I ask everyone to keep an open mind and have a willingness to do a little bit of give and take. I want to set the stage, right? I think that's really important. what I try to do is do a little bit of mirroring. It's hard for me to say mirroring. I think that's helpful. For instance, I cannot tell you how many times someone comes in, they've been seriously injured in a car wreck, or they've had a loved one who has died, someone was negligent. And they're all upset because no one from the other side has offered any condolences. They haven't sent a card. They didn't visit people in the hospital. They didn't send flowers. They didn't do anything. And that really rubs people the wrong way, right? Because they've suffered this big loss. They've had to hire a lawyer. They're in mediation. There's a court case. There's a trial date coming up. It's upended their entire life. And yet the other side doesn't have the decency to acknowledge that, right? Well, how do we handle that? Well, they'll say something, Paul, you would not believe that hand gestures. Well, I try to mirror that because I want to establish a little bit of rapport. So I say, are you telling me that no one came or visited or sent a card? Try to mirror what they're saying. You establish a little bit of rapport. And if they raise their voices at some point, nobody came, Paul. Now, I'll talk to them and I say, wait a minute, did you tell me that no one showed up at the hospital? Seriously? Tone, volume, it kind of matches what they're saying. Also, I don't know why, but people show up at these mediations. It's usually the injured party, spouse, sibling, significant other, parents. It's just not the injured person normally. It's injured person or the executor of the estate, 2 or 3 people, lawyer. So it's a group. But someone will always show up wearing some sort of a sports thing, right? I'm a sports fan, right? Cubs fan. Well, just the other day I had somebody show up wearing a Philadelphia Eagles sweatshirt. Well, that was really good. I know a little bit about football, just enough. So I tried to get a little bit of, discussion going about the Eagles, which helped. It helps later on. So all I'm saying is there's some things you can do in the initial meeting that I think are really important, that when there are disagreements later on in the second phase of the meeting, maybe they're not quite as intense as they would be otherwise. That's my goal. The disagreements are going to happen, can't avoid that, but let's make sure they're a little less intense. And I try to throw the responsibility for the meeting back on these people, right? I'll say, well, there may be some compromise involved today, and I understand it's probably going to be a little bit difficult for you to do. But I can just tell from meeting you folks that you're willing to do that, you're willing to keep an open mind, and I think I can count on you. So a lot of times that does not work, but I've let them know they expect some things from me as a mediator. Guess what? I expect some things from them. I expect no interruptions. I expect a respectful tone, a willingness to compromise and keep an open mind. So they may not abide by that, but that is my expectation. I try to tone that right up front. So I wanted to at this point, I wanted to show a little bit of a video. Why do I show a video? Well, I go to a lot of legal seminars. We have to get 15 hours of continuing legal education every year, where there's a little thing that happens if you don't do that. You can't practice law anymore. Okay? So we have lawyers come in from Houston, and New York, and Dallas, and they tell us what they're doing, which is usually pretty good, and what we should do. But there must be something built in the lawyer's DNA. There must be something on the bar exam that I missed, because invariably you have to show a movie clip. And you have to show a movie clip from a lawyer movie. You have to do it. Although I have to say, after watching maybe 45 video clips of My Cousin Vinny, okay, it's a great movie, but you don't have to show that anymore, right? Mrs. Riley and only Mrs. Riley. I've heard that, so maybe we could play this first video clip. Do you think it's going to work now? This is from Aaron Brockovich, which I think is a pretty good movie. So I'll offer a technology prayer. Click the button. We'll hope it works. so here we go.
Dollars is more money than these people have ever dreamed of.
Oh, see, now that pisses me off. First of all, since the demur, we have more than 400 plaintiffs, and let's be honest, we all know there are more out there. They may not be the most sophisticated people, but they do know how to divide, and $20 million isn't shit when you split it between them. Second of all, these people don't dream about being rich. They dream about being able to watch their kids swim in a pool without worrying that they'll have to have a hysterectomy at the age of 20, like Rosa Diaz, a client of ours, or have their spine deteriorate like Stan Bloom, another client of ours. So before you come back here with another lame-ass offer, I want you to think real hard about what your spine is worth, Mr. Walker. Or what you might expect someone to pay you for your uterus, Miss Sanchez. Then you take out your calculator and you multiply that number by 100. Anything less than that is a waste of our time. By the way, we had that water brought in special for you folks. Came from Well and Hinkley.
I think this meeting's so fun.
Damn right it is.
Okay, then. That clip has nothing to do with funeral directors, but I just like this. So let's see, I've covered everything on my list. Oh, this comes in, I think, it can be important later on or important during the initial meeting. There's probably a list of things that you need to agree to do a comprehensive funeral plan. Well, same thing with a legal case. We have to check a lot of boxes, so I keep a running list. And depending on how the meeting goes, I'll either show that list at the first meeting, first 3 innings of the 9-inning game, or I might wait till there's a disagreement. But the point is, it's helpful if you have several check marks in your 8 boxes, like 3 or 4 check marks. Hey, let's say there's a disagreement. Hey, you know what? You guys are getting a little discouraged here, but look at this. We checked off 4 of the 8 boxes already. We're doing pretty good here, and we just need 4 more to go. So, and I always try to do the low-hanging fruit first. Like in a court case, a low-hanging fruit might be a confidentiality term. Sometimes they insist on it, but a lot of times they can let that go. So we can get an agreement there, that's a check. So I try to keep that going. I also tell them, I'm going to make some suggestions here as mediator. Why am I doing that? Well, because I'm here to work with everybody. There may be some disagreement on what to do. I'm going to step in and make some recommendations, so be prepared for that. I'm not trying to take over the meeting. That's not my role. I can't decide anything. That's up to you folks. But I can help by making these suggestions and guide you along the process so that we can reach the main goal. Main goal in a funeral, right, is to have what? Good service, right?
Meaningful service.
Yeah,
Very old.
meaningful one, right? Well, the goal in a court case, of course, and mediation is to get a settlement. So I try to remind them, let's keep our eye on the ball. I'm going to make some suggestions here. I'm going to ask you for permission before I make the suggestion. And that's where I think my role deviates a little bit from yours, because I don't know any of these folks when they walk in the door. I practice law in West Des Moines. These folks might be from Carroll or Cedar Rapids or, Des Moines. It's a big place. I don't know them. I know the lawyers. I don't know them. You probably work with a lot of people in the community and you know them or know them. So that's a little bit different, but I try to ask permission. All right, so, one last thing. There are 3 things I tell them I don't want to hear, I can't hear. And again, I'm not trying to be a hard-nosed or a know-it-all, but I say, if we're going to have a successful meeting today, there are 3 words that I really don't want you to use. Always, never, and bottom line. I guess that's 4 words. They may be thinking those words, which is fine, but once they say them, guess what? Pride becomes involved, reluctance to retreat from an announced position. That's where the problems come in. And by and large, my experience is people, if they start to use the word, they'll catch themselves and say, okay, all right. I'm not going to say always, I'm going to say that's my strong preference, or whatever. But I try to lay that groundwork too. Okay, so the disagreement stage. I don't know how funeral planning works, but there's a lot of things that have to be agreed upon in a court case if you're going to get a settlement. And usually there are disagreements. Money is, not surprisingly, the number one thing. But there's a lot of other things that need to be covered. So a lot of times, I call them the thunderstorm. There's someone in a group, usually it's the injured party, who just has to get stuff off their chest, which I think is fine, but they're not going to be in a position where they listen until they vent a little bit. So I call it a thunderstorm. And like most thunderstorms, they come on kind of quick. They're pretty bad when they last, but they tend to dissipate fairly quickly. I let them go on. There's a little bit of balancing act there because they can't go on too long, right? But I let the thunderstorm pass by. The disagreement comes out. Then we can work on it. They're usually a bit calmer after that happens. So I'm going to use as an example from here on out a mediation, a made-up mediation. Let's say there's a nurse who works for a large hospital corporation here in Iowa, has a back injury, pretty significant, has surgery, not a great outcome, has got some work restrictions. Hospital took her back, but put her in a different job, less autonomy, more grunt work, menial work, and less pay. But she's still working there, does not like her supervisor, but really enjoys the people that she works with because she's been there for 15 years. Okay? So, it's a work comp case. She wants $280,000. The hospital says, we'll pay you $90,000. Okay, well that's a problem. They also want her to sign a global release, which means she'll waive any claim that she ever has against the hospital. Harassment, discrimination, equal wage violations, the whole thing. And here's the kicker, it comes with a resignation of employment, a voluntary resignation of employment, which is kind of bad because if she voluntarily resigns, her unemployment claim, done, can't get unemployment. So that's a big deal. It's also a big deal because let's say this fictional hospital corporation has a bunch of clinics and doctor offices all over town. And they're going to want that global release with a no reapply provision. So she can't reapply for any of their affiliates. And she's a nurse, she's 38 years old. So that's a problem. So how do we deal with that? Well, I think there are some magic, I call them magic words, they're not magic words, and a lot of times they fail. But I can approach the nurse and say, these are 3 words that work a lot. Would you consider? Would you consider? And I throw out a question. They're at 90,000, it looks like they're going to quit at 100. Just let them know, and I don't think they're going to move on to global release. Would you consider a settlement for 120,000? Just throwing that out there, I want to take your temperature on the idea. Now, a lot of times that won't work, but it gets them to thinking, and a lot of times it will work because studies show 93% of people describe themselves as someone who is willing to consider options, willing to keep an open mind, have common sense, and they're reasonable. Well, this appeals to their view of themselves and gets them to think. Also, it shifts the focus. It kind of introduces a new scheme. Instead of looking at it from she may be emotional, she's tied to the job. Now she's looking at it as, okay, the script is now, this is a number that the mediator thinks is reasonable. Maybe I should consider that. He's a neutral. He's not here to favor one side or the other. I'm going to think about that. So that's one option you can try. Would you consider? It works more often than you would think. It really does. The other three words, which I try to use, if that doesn't work, there are three other words that I use later on in the negotiations. And those words are, you could justify. So let's say the insured, or the hospital has put a final offer on the table of $135,000, which she believes is $35,000 more than they would ever pay. But they want a global release. Well, I could go in and say to her, you could justify accepting this. And give her reasons why. First of all, hey, you're only 38 years old. You have a good track record with this hospital. There are plenty of other hospitals, clinics, jobs that you can apply for. You have a really good resume. So what we do is, do you want to stick around this hospital where you feel you're being mistreated and you go home every night and you're stressed out and it's affecting your relationship with your family? So we've flipped the script from an emotion-based decision to more of a fact-based decision. You could justify this because it gets them thinking, well, here's what Paul has laid out in terms of facts, and I really can't dispute. I do go home at night. I'm exhausted, I'm stressed. I don't like my supervisor. I'm worried that they're going to can me anyway. He's right, there are other jobs out there I could get, and you know what? Maybe it would be better for me mentally to consider that. Plus, I get some money to tide me over. So, those two options, I think, can work. And more importantly, it just flips the script a little bit from emotion-based to fact-based to reasonable suggestions from the mediator. So, before we run out of time, I'm going to show the second of two videos. It's a lawyer video. Sorry about that, but let's play it. Okay, this is from the movie The Verdict, which I think the acting is wonderful. And during the movie, it's not all real life lawyer stuff, but a lot of that does happen in real cases. So I kind of like it for that reason. Paul Newman is a lawyer representing a malpractice victim in a Boston courtroom. The judge is known as a defense judge who is not giving Paul Newman any slack on any of his rulings. In fact, has questioned a witness just before this meeting and has elicited testimony from the witness that hurts Paul Newman's case. So he's trying to convince the judge that, look, you need to be a little more neutral and can reconsider your rulings, but he doesn't. The meeting goes awry, so let's take a look at this video. It's about 2 minutes long.
I've got to write to the Board of Bar Overseers about you today, fella. You're on your way out. They should have kicked you out in that Littlebridge case. Now this is it today.
I'm an attorney on trial before the bar, representing my client. My client. You open your mouth, you're losing my case for me.
Now listen to me.
No, you listen to me. All I want on this trial is a fair shake. Okay? Pushing me to court 5 days early. I lose my star witness, and I can't get a continuance, and I don't care. I'm going up there, I'm going to try it, I'm going to let the jury decide. They told me about you. Said you're a hard ass, you're a defendant's judge. No, I don't care. I said to hell with it, to hell with it.
Many years ago.
Come on. Hey, don't do that shit about you being a lawyer, too. I know about you. You couldn't hack it as a lawyer. You were a bag man for the boys downtown, and you still are. I know about you.
Are you done?
You're damn right I'm done now. I'm going to ask for a mistrial. I'm going to request that you disqualify yourself from sitting on this case. I'm going to take a transcript of the trial to the Judicial Conduct Board and ask that they impeach your ass.
You are going to get it, Miss Trial Boy. We're going back there this afternoon and we're going to try this case to the end. Now you get out of here before I call the bailiff and have you thrown in jail.
So I don't think that meeting went exactly as Paul Newman planned. And needless to say, the rulings against him kind of continued during the trial. There one thing I really liked about that video too is the lawyer in the background who was standing against that's James Mason, he's the defense lawyer. A classic case of when your opponent is digging a hole, don't stop him, right? He didn't say a word. All right, so we've covered the two things to try to get things moving again in a positive direction. There's three other things I think you can do. We talked about this earlier, but if you haven't tackled some low-hanging items, you could get those out of the way. I'm sure in your business, you probably have some things that people will agree to without too much difficulty. At least that's the way it is in court cases. Then, what sometimes I do is I try to trade. If there's several things that they can't agree upon, we kind of do, I introduce some trading. Hey, in exchange for, let's say, more money, would you agree to get an allocation that is more favorable to you on a tax basis? That's a trade, and the two sides might agree to that. What that does is, instead of having 4 agreed items and 4 disputed items, you've narrowed it to 6 agreed items and 2 disputed items. So you need to identify what's important to each party and see if you can make a trade on equally important items, okay? The next thing that you can do, and I kind of like this phrase, it's called an Oklahoma, which I think is kind of cool. And by the way, lawyers have a very low bar of what is cool. Well, we call this an Oklahoma, although if you're from Nebraska, you call it an Omaha. So an Oklahoma is you approach one of the groups and you say, hey, by the way, if I could get them to increase their offer from 110,000 up to 140,000, would you agree to reduce your demand from 270 down to 210? And if I get a positive response, I go in the other room, talk to the hospital, and I say, hey, we need to make some progress here. What if I could get the other side to move to 210? Would you then increase your offer to 140? So it's done privately. Hopefully you get 2 yeses. And it's just a what if kind of thing. On Oklahoma. And it does work. That's another thing that you can try. I use that quite a bit. I try to match up what I'm asking each side to do so that they think there's being an equal lift on both sides. Because it'll become clear, I think, during most legal mediations that one side wants something above all else. The nurse wants the money above all else, not surprisingly. The hospital wants the global release because they view this nurse as a liability. The next injury she has could cause her to be permanently and totally disabled. So instead of getting benefits for a certain period of time, she's going to get lifetime benefits. It's a big deal. That's why they want the global release. So you can't go in and ask someone to agree to a global release unless they're getting, let's say, items 2 and 3 in return. It's got to be an equal thing. All right, so that brings me to, I don't like to call this the last thing I try, but let's assume that none of these things have worked, and we're still stuck. Maybe the parties have gone to 110,000 and 280, whatever. It's not working. Well, if you've developed some rapport with these folks, you can try, and I'll refer to funeral directors in this situation as a mediator, okay? Because I kind of do that. How about a mediator proposal to resolve this conflict? That's usually one of the last things I try. And I don't know how long your meetings last. I have no clue, but legal meetings could go on all day long, and I take advantage of the time because by 4 o'clock in the afternoon, the 2 sides are exhausted. So they'll say, yeah, come on in with a proposal, we'll listen to it. It's all done privately. If one group agrees, the other group doesn't find out unless they also agree. And everyone has to agree to the entire proposal. They can't pick and choose. And they can't come back with another proposal. Okay, so thumbs up, thumbs down. My experience is that works. And again, you have to have the 2 sides in separate rooms. rooms, I don't know, again, if you have 2 conference rooms where you could put people in different rooms, it really, really helps. So that's an option we can try, but it's kind of a last option. And if that doesn't work, we gotta get a drink of water. Some people would say, well, we're at an impasse. And I've heard that term, I probably used it myself. I looked it up in the dictionary the other night. And the dictionary definition is a predicament offering no obvious escape. Predicament offering no obvious escape. So people might say to me, well, it looks like we're at an impasse. I guess we'll roll up the hoses and go home. Well, no, there's some stuff you can do. You have to try a different approach. So depending on the people involved, I try to ask a hard question. A hard question would be, well, what do you envision now going forward? If you walk out of here without a settlement, the trial's in 3 weeks, what's going to take place? How's your life going to be for the next 3 weeks? And we talked about jury verdicts. I've showed you some. Do you think you're automatically going to win this case? Take a look at what's happened in Polk County in the last 5 months. Hard questions. What about your family? Do they want you to do this? And what happens if you lose this case? Now, here's a nuclear option. If there's really been disagreement, voices raised, maybe some cuss words used, I asked them, well, during this meeting, let's say it was live streamed, and how would your children view this meeting so far, if they could watch the live stream? Is that helpful to you and your family? So I ask hard questions. Then I ask, what is really keeping you? We need to make a tough decision today, and it needs to be today, or you're going to trial. What's keeping you from agreeing to these terms? You need to tell me what is keeping you. And normally at that point, they will tell me what is keeping you. It might be jealousy. It might be fear. It might be they don't like their lawyer. Who knows? It might be that instead of focusing on the true value of the case for settlement purposes, they're trying to reach a dollar amount that will allow them to do this and this and this, which shouldn't enter into the equation. New information can also help. So I had a mediation recently where someone told me in private, I don't want you to disclose this to the other side, but we will not insist on a global release. We want one desperately, but in the end, we might be willing to give that up. So I stuck that in my back pocket because I could tell from the tenor of how the mediation was going that I probably need it. So my experience has been that people want to settle if they've said no, but at the end, if they're presented with a new term or new information, that's just enough justification for them to say yes. So at that mediation, I said, well, I'm allowed to tell you that the employer here will not insist on a global release as long as you agree to the dollar term we put on the table. Boom, 10 minutes later, we got to sell it. And that mediation lasted all day long. And I was kind of glad I kept it in my back pocket. One thing I've done, and this probably would only happen once or twice, but I used it in a family farm dispute. There are some really bad feelings between 5 siblings. They could not reach an agreement. And I had made a proposal, it failed. One of the spouses, I just got the feeling, she didn't say very much the whole time, but I could tell that she was respected within the family. She didn't get upset. She made a few comments, but they were right on. And you could tell that she was just liked. So I asked the other 9 people, the 5 siblings and the other 4 spouses, if they would agree that she would make the decision on the last disputed issue. She would be the decider. It worked. I don't know how, but it worked. So the last thing to do is just adjourn. Call people the next morning. A lot of times they'll go home, they'll think things over, and might talk it over with their spouse, have a more candid conversation than they had with you. Because you don't know how the spouse feels or the adult child about all of this. They're not going to show all of their cards. And so things can change. So that's what I wanted to tell you. I hope you had a takeaway or two from this. I hope too. If there are any questions, yeah, please, sir.
What percentage of cases do you settle in mediation as compared to what goes to trial?
Well, at mediation, 85% of my cases settle, and of the 15% that don't, about 2/3 to 3/4 of those settle within 10 days. So very few cases go to trial. I have a hammer that you guys don't have, which is there's a risk that the jury might come back and give the injured party nothing. Juries are cold. They're cold. If they don't like it, if they don't like your case, they're gonna shut you down. That's the hammer I've got. The other hammer I have, in some cases, is delay, which you don't have, right? You've got a funeral to put on, continuances, ever since COVID, the courts are jammed with criminal cases and family law cases. They can't get to civil cases very quickly. So I've got that hammer to use. But that's the reason why most cases settle. So, and you know, a good settlement is when nobody walks away completely happy. That's too tough at the beginning. Thanks very much for listening.